Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She owns a real estate and family law firm in the Worcester area, and she is fantastic. Today, we are going to be learning about yet again more tricks of the trade and things that we need to know about real estate. And the topic today is purchase and sales agreements. These are really tricky. Welcome to the show today, Nicole. Thank you so much for joining us.
Thank you for having me.
Why don't we talk about first, like we always do, what's the definition of a purchase and sales? What is it?
So, purchase and sale in its entirety is a contract. It's a binding contract between the buyer and the seller, and sets forth the terms as to who's going to purchase it, when they're going to purchase it, for how much, and what is included or not included. So, we're going to go through all of those steps and learn more about what we need to know about that document and what its significance is.
So, when would you use a purchase and sales?
You're going to use it after the offer to purchase. So, generally speaking, when you make an offer on the house, it's going to be accepted, and it's going to be a one-page document, maybe have 5 paragraphs, really simple document that just sets forth, hey, I really want to buy your house, and I'm going to buy it for $300,000. And that's really all the gist of what the terms are. It'll tell you when you're going to close on it. And then the purchase and sale is a supplement, if you will, to that offer to purchase. So it's a more encompassing document. It's anywhere from 10 to 15 pages in length, and it's going to outline every single thing that you could possibly come up with from now until the close of that property. So it's going to be very encompassing of all of the information so that we have it in one concise spot, and it basically supersedes the offer to purchase. So this offer to purchase becomes void upon signing the purchase and sale agreement.
Now, is it pretty standard? I mean, you and I have worked together on real estate, and I remember this one time we had someone that turned the offer letter into more of a purchase and sales, and it just lasted forever going back and forth. I don't know if you see that very often or if that was just a unique situation and talk about what we can do about it, I guess.
Absolutely. It does come up every once in a while. It usually comes up because brokers want to be attorneys. In Massachusetts, drafting of a purchase and sale agreement can only be done by attorneys. And if a broker is doing it, they're practicing law without a license. So it's really something that they need to stop doing. And they try to do it and be sly about it. And unfortunately, they don't have the degrees. They don't know of all the ins and outs of an agreement. So they really don't understand exactly what they're getting their clients to sign. So certainly you want to have it done by an attorney, and you want to have it done between the attorneys. The brokers can certainly give their insight if there's any issues regarding a home inspection or something of that nature. But really, it should be between the attorneys because it's a legal binding contract. And if somebody does breach on that contract, that's what we get to sue on.
So how long does the purchase and sales agreement usually last? I know there's a timer on that because everybody wants the deal to move forward and they don't want their property being tied up if the sale is not actually going to go through. What's the standard amount of time?
The standard is usually under 2 months. It's anywhere from 30 days to 60 days on average. There are times that we've extended out. I have one right now that's really been extended for about 9 months, but that's because we're having title issues. There's probate estates, there's corporations that were defunct and we now have to reopen. So those are kind of the out of the norm. And obviously they're willing to do it. And it's also a commercial property. So commercial property does have a tendency to be longer in length, but residential, generally speaking, is within 60 days. And again, that takes place from the date of signing of the purchase and sale through the date of closing.
And that makes a lot of sense. I mean, does it usually, everything that you wrote in the purchase and sales, does it usually last to the end when you're closing the sale?
It absolutely will last to the closing of the sale. That's what the whole thing is for. It's for this time period. The real question is, does it last after closing? And the simple answer is probably not, unless there's certain caveats. So certain paragraphs we will put in there that says, hey, this provision i.e., there's been no underground storage tanks survive closing because we're relying on you. And then if you lied to us, we want to be able to come back and sue you. Now, again, you being the seller has to have actual knowledge of it because I can't sue you if you bought it from two other people ago and you had no knowledge. But obviously, if you had knowledge, that's something that I would want to have survive. And generally, I do have survived that language. So there's paragraphs within the purchase and sale that may go beyond the closing. But again, now you have to talk to your attorney and look at specific language.
Yeah, no, I remember that. We had a situation where we were by a river, or going to be by a river if we bought that property. And they made us sign something that said they weren't responsible if we found anything in the land that's seeped into the river that would get the Environmental Protection Agency after us. And when people make you sign that, I feel like it's a red flag. How do you feel about it? You got to protect yourself, but man, there was a lot of things wrong with that property.
It's definitely an eye opener. I mean, and that's the good thing about it is, if people are reading it, should certainly go, what? Why is this an issue? And maybe it isn't an issue. Maybe it's just we're covering ourselves. Maybe it's something that happened 20 years ago and the statute of limitations has run. Maybe they did do something and you're going, oh my God. But that's the reason why we put that in there. So it does protect both parties. The reality is you as the buyer might go, well, I wasn't going to do testing, but now I'm going to do testing on it because, oh my God, I didn't know that this was an issue. So again, you're going to run into those issues. Usually it's with asbestos, underground water tanks, seepage into dwellings and waterways and stuff of that nature. I have one right now that has a dam on it that needs to be repaired. So again, you run into these kind of weird things every once in a while and you're like, I don't know. And you really want to do your research. You want to do that homework before you purchase it because you don't want to get involved and then go, oh, look, now I'm getting sued. That's not what this purchase and sale is about. And obviously it's there to protect you, but it's there to protect both parties.
So what else is included in the purchase and sales agreement?
So you're going to have obviously the parties that are buying it, the buyer's name, the seller's name. Maybe one of them is a corporation or you're putting it into a corporation name. You're going to have the date of closing. So when we're going to close on a particular property, what the anticipated date is. Hopefully we stay with that date. A lot of times that's going to be related to your mortgage and whether or not you need an extension on it. It will be including information about inspection. So if there was inspections, if there was a Title V done, if you're going to have a Title V certificate, if you had, ants or termites or other pest inspections, when are those due? Any repairs that you're going to be making as the seller as a result of those inspections, or any reductions that you're giving in the purchase price as a result of those reductions. You're going to have a mortgage title commitment deadline. So when your mortgage company is going to give you the commitment to buy that property. So I need $300,000 to buy this property. I'm getting a loan for it. Okay, there's a date in there that says I need to provide that and provide that notice to the other party saying I do have it or I don't have it. You're going to have information about what title looks like. And title for you really doesn't necessarily matter as an individual. That's the reason why you have an attorney, so that they can look at the title and see what is on there. There might be easements on there that you're freaked out about. Well, unfortunately, guess what? You're going to have that underground telephone pole, or not telephone pole, but underground electrical things and FiOS and stuff of that nature that, guess what? You can't dig up. You don't have that choice, and they're allowed to keep it there because it's an easement, but it runs underneath your land. So there's things that are not going to matter. And then there's things that are going to matter where you have the next door neighbor shares the driveway with you and you're obligated to do all the repairs. Oh my God. Those things you might need to know about. So again, there's a lot of nuances that are going to be in that purchase and sale that the attorney's going to look at, not only to protect you, but also to advise you and say, do you understand this is what you're getting?
So what are the benefits of having each of these things in your purchase and sales agreement? And when you get to inspections, I'm curious as to how often a scary inspection helps you lower a price, because so far people have just dug in on me, and even though their places are falling apart, they don't want to take a dime less. I mean, that must be common.
It is common, and I think it's really a matter of how good your broker is able to articulate. Some things are going to be, hey, look, we're not going to worry about stupid things. We're not going to worry about paint. Like, who cares? The paint is what you saw. You knew that the paint was peeling. Why are you having this problem? We're really talking about those hidden gems that we didn't know about. The boiler that's on its last leg that we're not HVAC people. Why would we know that, right? The roof that we can't get up and see because it's a 3-story building and we're like, it looks good to me, or there's snow on it and you have no idea. And the inspector goes up and goes, this is rotted through. It's the person that goes through the crawl space and, there's this much room and he can, shine a flashlight up there and see that there's mold growing in there. And we get tested for mold. So those are the kinds of things that, again, they're hidden things that we didn't realize until we had the home inspection come through. And then really boils down to, okay, now as a result of that, what's going to happen? If you have a radon test and it comes back and it's over 4, we're going to look at it and go, okay, well, we have to do a radon mitigation system. We all know how much that costs. That's about $1,500 on average. Okay. Mold remediation, again, depending on the square footage of the area, again, you're looking at probably $2,000 to $4,000. So some of these things, they're in our wheelhouse. Anybody that does this for a living is going to know how much to do it. And then there's the other things that, I had a staircase that was pulling away from the front of the house. Well, you didn't realize it because, yes, we saw it, but nobody ever thought, hey, look, the stairs are moving away. And that's what home inspectors found. And we had no idea what the cost was. And we asked somebody and they said, oh, staircase is $300. Okay, now we know. So again, it's something simple that we need to first know out what the cost is, and 2, how that's going to impact the mortgage and how it's also going to impact the sale and whether or not we're going to get any offsets. And again, that goes back to your broker knowing the numbers, your broker negotiating and saying, hey, look, we gave you high end on the list price. We gave you full asking price, but now we have all these conditions. We didn't know about it at home inspection. They were clearly hidden. This is the cost is going to cost us $10,000. We want at least $8,000, whether it be reduction in price or closing cost credit or something of that nature. But that's where you really want to rely on your broker to go, look, this house is overpriced and we did this for you, but we're not willing to concede. And then the other part of that is really, again, from the buyer's perspective, are you willing to concede to certain things? Both parties have to either say no or they have to agree. And if you have good people negotiating for you on each end, that's where you're going to be able to come to a meeting of the minds. So that's really how we get to that inspection repair provisions. The mortgage contingency is going to be started with listing in the offer to purchase. And that's just an extension of that. And it's usually going to be 10 days before closing. So 10 days before closing, the bank's going to need all of the documentation so that they can close. And they're going to give you the mortgage commitment. And it's going to be for amount that, again, you put in the offer to purchase. So if it says 80%, then that's what you're paying. Your 80% is your mortgage and you're paying 20% down. So we're getting those numbers from the original document, as well as we're getting those numbers from the offer to purchase for the closing date. For any repairs are obviously going to be the inspections. And then if the mortgage and title issues are really going to be standard language that we're going to put in, that again, the attorneys may tweak depending on what they've seen in their lives. Unfortunately, we've seen everything. We've kind of addressed everything. We know what goes to litigation. We've talked to REBA seminars and stuff of that nature where we know how to tweak language. So obviously we're putting all this information together that's going to best protect our clients.
I mean, that's all very important and interesting. And I feel like one of the most important documents when you're trying to sell or buy or sell a property is the initial P&S, because like you said, it does last to the end of the deal. And it really keeps everyone honest.
Absolutely does. And, it's also a guideline. Well, who's breaching? Well, the document speaks for itself. Let's go read it. And it really boils down to how we're going to read it. More importantly, what the reading says. Again, does it say may do this or shall do this? 2 completely different interpretations based on those words. So we really need to look at what that says and how we're going to apply it, because the court is going to look at and read the plain language. If it says shall, it means shall. No ifs, ands, or buts about it. If it means may, it's discretionary. And so again, that's something that you need to talk to your attorney about and know what your rights are.
So thank you so much for sharing this with us again today, Nicole. We absolutely appreciate all of your advice. And anyone that needs a real estate attorney or a family attorney, please call Nicole and her team in the Worcester area. They're phenomenal, and they have the strategies that help you get the outcomes that you're looking for. Thanks again, Nicole.
Thank you.
And thank you everyone for watching. Have a great weekend.